we're going to start with you, Assemblyman Brodsky. This is, what do you think about maintaining databases involving people who have committed no crime?
Thank you for the
first 29 seconds to get over his indignation.
I'm against it.
Not my question, just for the record.
I'm against it. I debated on the floor in support of the Jeffries bill that required New York City to change its views, change its practices. I think the practices in Nassau County, which I've asked District Attorney Rice to reveal by filing the Freedom of Information Act, are parallel and equally unacceptable. And I'll have more to say about it shortly.
I worked on this bill. It came out of my committee, the bill to stop them from keeping the names of innocent people in a database. I strongly support it. I do also view the next Attorney General's role as also playing a big part in the effort to transform the American justice system, and to me that does include the criminal justice system. And I think that the database is only a small part of a much larger problem of over-investigating and over-incarcerating people from certain communities, and that's something that I've worked on for years, and I certainly will work on as Attorney General.
I think we all stood in favor of the passage and the signature by the governor of the bill. I thought the database turned innocent until proven guilty into guilty even when the cop on the beat found you innocent. I think that the systemization and institutionalization of stop and frisk goes well beyond the intention of the Supreme Court in Terry versus Ohio, and I would take a serious look at whether that approach by a city to basically send its entire police force out in a stop and frisk state of mind every hour, every day is in fact constitutional or not.
All practices throughout the state in any city, not just New York?
Well, we could do it. I mean, I think that the New York City Police Department has been the clearest on how it's taken that case, Terry versus Ohio, which is sort of a one-off situation between a police officer and a suspect, and blown it into a institutionalized systemic approach of law enforcement with a lower standard than probable cause. And I'd like to explore whether that approach, as opposed to the limited, one-off situation, is in fact constitutional.
And there's no place else in the state that has taken the same course as New York City. What Richard was talking about in Nassau County is a different invasion of the rights of the innocent, perhaps, but it's not the same kind of databases.
This is going to be a debate question. The RAND study finds us 25% higher than what you would predict for a city our size, and there is such a thing as de facto discrimination as opposed to jure. So if the facts show that it's a discriminatory approach, maybe not intentionally, but de facto, I think that's a real undertaking.
I'm going to say I disagree with it. We don't know what's going on in other communities across the state, and that the Nassau program is an electronic stop and frisk program. They take innocent people, drive them through what they perceive to be a high-crime neighborhood, they take pictures of the license plates, they mine it through a license plate recognition system, and they send them threatening letters. I don't see a moral distinction, and I'm not even sure a legal distinction, between that and actually stopping someone.
Sean.
They're both unacceptable.
We all agreed that the bill that would ban the use of the database should be signed. We're all glad it was signed. I think there is a deeper, more difficult question, which is how stop and frisk is being applied in New York City. I think stop and frisk, when used constitutionally and appropriately, is a good law enforcement mechanism. It keeps neighborhoods safe. The problem, the way it's being applied, as I see it, is that there are quotas being forced down to the street level to have police officers go out and generate numbers. Once they made stop and frisk a reportable activity using the UF-250, you could measure it, and once you can measure it, you can do trends, and there can be pressure. And I was appalled to read in the Village Voice expose on the 81st Precinct in Brooklyn that if you were a minority in Brooklyn, in Bed-Stuy, you were better to stay inside the last 3 days of each quarter because they were out there trying to meet their numbers. That's no way Americans should be treated. So I believe we should mend it, not end it, and I think as Attorney General, based on the statistical evidence I've seen, based on the anecdotal evidence that's emerging from the 81st Precinct, and I use the analogy, when you turn on the light in the kitchen, there's one cockroach, it's probably not alone. I think that's an isolated instance. We need to do this blind because it's counterproductive to crime fighting. Crime is way down because of the partnership between police and community. This threatens to erode that partnership. I disagree with Commissioner Kelly. I think the consequences of not signing this bill would have been an increase of crime, not because some database couldn't be served, but because fewer people would have trusted the police and we would have returned to the bad old days of the 70s.